Let me now tell you a few more words about our lecturer. Unfortunately, our second lecturer, Professor Margaretha Weverinke, has not been able to join us for personal reasons. She just informed us a few hours ago and expresses regrets and apologies. We will certainly regret her absence given her expertise and the importance of her role in the diplomatic and judicial process which will be presented today. I turn now and introduce Professor Kate Mackintosh, who is Executive Director and Professor from Practice at the UCLA Law Promise Institute in Europe. Professor Mackintosh has an extensive career in human rights and international criminal justice, holding senior positions across civil society organizations, academia, and the UN. She currently serves on the International Council of Experts on the Investigation of Crimes committed in armed conflicts in Ukraine, as well as the advisory group for the International Criminal Court Prosecutors Policy on Environmental Crimes. She represented the State of Palestine at the ICJ, International Criminal Court of Justice, not criminal, International Court of Justice, in the context of the request for an advisory opinion on states' responsibility in the face of climate change, of which we're going to talk today. From 2020 to 21, she was deputy co-chair of the independent expert panel for the legal definition of ecocide, and she's a member of Stop Ecocide International, whose founder and CEO is Mrs. Jojo Mehta, who has already been a fantastic lecturer in one of our Entretiens 2 years ago, and who recommended us to invite Kate for such an Entretien. Both have been, Kate and Margaret had been directly involved and played an active role through the whole initial advocacy and diplomatic process, which led to the adoption of the totally landmark, decisive, and historic advisory opinion adopted by the International Court of Justice last 23rd of July 2025, just a few days after the 2025 Global Overshoot Day, which took place on the 25th of July. Both had been invited to address the ICJ as experts in the public hearings organized in December last year. No doubt that their expertise and Kate's expertise, have contributed to influence this decisive decision of 140 pages, unanimously adopted, which constitutes a great victory for climate justice at a time when climate crisis is dangerously accelerating. Enormous temperatures and disasters keep rising, and those less responsible suffer the most. An incredible journey initiated by the courageous initiative of Vanuatu and a coalition of Pacific States Island, in which some 130 co-sponsors prompted the UN General Assembly to adopt a resolution in March 2023, formally requesting the International Court of Justice to issue that particular advisory opinion on states' obligation under international law to protect the climate system and the environment for present and future generations under international law, but also the legal consequences for states whose actions or omissions cause harm now and in the future. To quote the UN Secretary General yesterday in inaugurating the General Debate of the General Assembly, it is a victory for the planet and climate justice at a time where present climate crisis constitutes an urgent and existential threat for all forms of life and the very health of our planet, according also to the President of the Court. Our lecturer will certainly analyze the content and potential of this opinion. I will just underline one among many of the critical conclusions. ICJ recognizes, as I said, that states have a legal obligation to protect the world climate system for present and future generation and prevent any significant climate harm and to fully repair them. I shall remind non-lawyers the importance of such an advisory opinion. knowing that the ICJ contributes to the understanding of the fundamental values of the community of states expressed in international public law, and that its dicta are unanimously considered as the best formulation of the content of international law in force. And I shall remind the imperative of international law. I shall now invite our lecturer, Kate Mackintosh, to take the floor.
Thank you very much. And as was mentioned, I'll be speaking in English as advertised. Juste pour parler en français pour un moment, si vous voulez poser des questions en français ou si vous voulez que je répète quelque chose en français, n'a pas de problème. But as we prepared this in English with my colleague Margareta Varenka Singh, I'll continue as planned. So the title of the lecture is deliberately provocative. Can the ICJ's climate ruling save the planet? Of course, no single court ruling can do that on its own. But as was just foreshadowed in the introduction, the International Court's recent advisory opinion on climate change really is a landmark moment. It clarifies obligations, it sets standards, and it provides tools for states, courts, and all of us around the world to act. So the origins of the request have already been referred to. The journey for this advisory opinion began in the Pacific. And I do want to mention that because it's so remarkable, and we really have the students of the South Pacific to thank for this landmark opinion. In 2019, students at the University of the South Pacific launched a campaign targeting the Pacific Islands Forum, calling for the world's highest court to rule on climate obligations. And despite some initial skepticism, as I understand, in 2021, the Pacific Island state of Vanuatu took the lead. And at that time, I just want to read some of the words of Prime Minister Bob Lamon, what he said. He said, "This is for the world's most vulnerable, for all of humanity and our collective future. This is about what we must save, not what's been lost. This is a campaign to build ambition, not division. This is a campaign to uplift the goals of the Paris Agreement. This is the young generation's call for justice to the world's highest court." And then, really remarkably, by 2023, on the 29th of March 2023, this campaign, which had started in the Pacific Islands, led by the tiny state of Vanuatu, was successful in getting the UN General Assembly to adopt by consensus this resolution asking the International Court to clarify states' obligations and to clarify the consequences of violating those obligations. So this really was a remarkable diplomatic achievement. So you may be well aware of what the advisory opinion is, what an advisory opinion is, but just to recap, the International Court of Justice, of course, was set up to settle disputes between states. It was a crucial part of the World War II, post-World War II architecture, principal organ of the UN. The idea was that states will no longer go to war, they'll go to court. And this is the court that's going to settle their disputes. But it also has this advisory role. At the request of the General Assembly or the Security Council or other organs authorised by the General Assembly, the court can deliver guidance on a legal question. So you do have to get the whole General Assembly or the Security Council to vote, to put this question forward. It's a massive achievement. And I think this audience will recall a famous example, of course, the 1996 advisory opinion on the legality of the threat or use of nuclear weapons. So that was a case also born of deep moral and existential concerns. That advisory opinion was requested by a divided vote. There were 78 states in favour at that time, 43 against, and 38 abstentions. This resolution was passed by consensus. In other words, no one objected. And we can maybe discuss a bit more why that was. So advisory opinions are not formally binding, but they are highly authoritative statements of the law. So the difference between binding and not binding can be hard to determine. It would be almost unimaginable for a court at a national or international level to go against a determination of the ICJ on a matter of international law. So this is an authoritative statement of international law. Just a brief word on the proceedings, because these were also really unprecedented. So over 100 states participated. That is to say, over 100 states made legal submissions to the court on this question, and 11 international organizations, including the World Health Organization and the Organization of Petroleum Exporting Countries, OPEC or OPEP en français. The oral hearings in December last year lasted for 2 weeks, with each state being given 30 minutes, which is the longest ever in the court's history. And as we heard, on the 23rd of July, the court delivered its opinion. So, what did it say? Well, it said a lot. And in this lecture, I'll just highlight some of the key findings. So, first of all, the framing was important. The court recognised climate change as an, quote, urgent and existential threat. And it also recognised as authoritative the scientific reports of the Intergovernmental Panel on Climate Change. It described in detail the severe and far-reaching consequences of climate change, referring to rising seas, flooding coastal communities, to extreme weather, devastating agriculture and displacing people, to irreversible biodiversity loss, and to risks to human life and health worldwide. And I would really urge anybody interested to look at the submission of the state of Vanuatu, who was represented by my colleague Margareta Vivenkasinghe, who sadly is not with us, to look at the submission of Vanuatu, because in annex to their comprehensive and encyclopedic submission are statements that were gathered from Pacific Islanders, from communities living in situations where they're watching their heritage, their livelihoods, and their lands being washed away by climate change. And they're really very powerful. And this testimony was before the court in really quite a unique way for proceedings of this kind. So, as was outlined in the introduction, the question before the court was in two parts. The first part asked the court to determine what states are legally obliged to do to protect the climate system from anthropogenic greenhouse gases and climate change. So what are they legally obliged to do? The second part of the question was, what are the consequences of failing to protect, of causing significant harm to the climate system? So if we look at the first question to start with, the central debate between all the states who presented and made written submissions to the court was this. The large emitters, basically the countries from the global north, argued there aren't any legal obligations. The applicable law is the Paris Agreement, is the UNFCCC, the Framework Convention, the Convention cadre des Nations Unies sur les changements climatiques, and the Accord de Paris, which are voluntary agreements and do not set hard and fast rules. So, as you all will be aware, under the Paris Agreement, states determine their own contribution in terms of emission reductions. So basically the global north plus emitters said there's no binding law, there are no obligations. And they also said to the court, you want to be really careful about trampling on this carefully constructed political, diplomatic framework, which is the climate change treaties, which is voluntary, very fragile. And any suggestion that something is obligatory could blow the whole thing up and then we'd have nothing. Vulnerable states, the most climate vulnerable states of the global south argued otherwise. They pointed to human rights jurisprudence from international courts as well as national courts, to the recently delivered advisory opinion of the Inter-American Court on Human Rights, to the opinion of the International Tribunal for the Law of the Sea, and to general international law, and argued that there was a lot of relevant binding law which circumscribed what states were allowed to do and imposed duties on them, told them what they had to do. And to cut to the chase, the ICJ basically sided with the latter group. So it found that there are binding obligations on states under the climate change treaties. It found binding obligations under the Paris Agreement and the UNFCCC, and also under customary international law. So the court found two important duties under customary international law: the duty to prevent significant harm to the environment, as well as the duty to cooperate with other states, were both relevant to this question, and they both applied in the context of climate change. So the duty to prevent significant harm to the environment includes a duty to prevent significant harm to the climate system. That might sound obvious, but there were many arguments that that was not the case. And because of the urgency of the risk posed by climate change, the court said that the standard to be applied, so the states are under a duty to prevent. What does that mean? What does that mean? Well, that means that you have a duty of due diligence. You have a duty of due diligence. And actually, because of the urgency of the risk, the standard is one of stringent due diligence. It's like an elevated standard of due diligence. And this follows actually what the International Tribunal on the Law of the Sea had said back in May 2024 in their advisory opinion on climate change. So what does it mean if there's a standard of stringent due diligence? Well, it means that states must apply all reasonable means to prevent harm. And the court said that this has actually direct consequences for the Paris Agreement commitments. So states do not have an unlimited discretion to set their targets under the Paris Agreement. It is not a purely discretionary act. They are bound by this obligation to prevent harm and the standard of stringent due diligence, which means the nationally determined contributions must reflect the highest possible ambition. They must grow progressively more ambitious. This is already in the Paris Agreement. And collectively, all the targets of all the states together must be capable of keeping global heating to 1.5 degrees C above pre-industrial levels. So the court also recognised that target of 1.5 as legally binding, which is another important development. And then, very importantly for states of the global south, they said that the standards that apply, the targets that had to be set, must reflect each state's historic responsibility, as well as their current level of development and national circumstances. So reflecting the current level of development and national circumstances is bound up in the idea of common but differentiated responsibilities, which appears in the climate change treaties, but the recognition of historic responsibilities was very important. And the court also confirmed that states must regulate private actors, so corporations, so that their conduct aligns with these obligations. And in one of my own personal favourite passages, the court affirmed the existence of an autonomous right to a clean, healthy and sustainable environment. Now, that's something which had been affirmed by the Inter-American Court, for example, but it's not something that had been affirmed by the International Court of Justice. So if we look at proceedings in national jurisdictions on human rights grounds about climate change, and of course there have been many cases that have been brought, or even at the European Court of Human Rights, cases have to be made dependent on other rights. So my right to health is affected, or my right to life is affected, or my right to privacy is affected. But here the court is saying, no, you have an autonomous right to a clean, healthy and sustainable environment. So that's also a really important step forward. So turning quickly to the second question, which was the consequences of the breach. So what law applies? Well, the states said, the court said a lot of law applies. There are binding obligations and it sets out what they are. Second bit of the question, what are the consequences of breaching these obligations? Well, the court made clear that failure to protect the climate system may constitute an internationally wrongful act. In other words, a violation of international law. And they gave examples of what kind of actions might lead to that conclusion. And they included fossil fuel exploitation, subsidies to fossil fuel companies, inadequate targets, granting licenses for fossil fuel exploration, they indicated that all of those things may constitute internationally wrongful acts. Very importantly, also, the court dismissed claims that it was impossible for contributions for greenhouse gas emissions to be traced back to individual states. This was another major point of contention in the presentations to the court, that the issue of causation was too complicated and it was impossible to trace particular effects of climate change back to specific emissions. And the court dismissed that. It said contributions can be traced. And it confirmed then that the usual rules of state responsibility apply. In other words, if causation can be proved, that reparations are due from states who've violated their obligations, states who are responsible for an internationally wrongful act. And under international law, reparations include restitution, putting things back to how they were before. That's probably quite hard in this context. If that's not possible, then compensation. And there's also satisfaction, which may include apologies, memorialization, other actions which repair in some way the damage that has been done to the victim state or group. If causation, they also pointed out, which is interesting, that even without showing causation, without tracing that causation line, so causation is important for a claim of reparations, but actually to determine whether there was an internationally wrongful act, the causation is not necessary. All that's necessary is to show that there was an obligation and that obligation was breached. And in that case, there are other claims that can be made under international law, including cessation, stop doing it, or assurances of non-repetition, make sure it doesn't happen again. And by the way, small aside, among the assurances of non-repetition or the making sure this doesn't happen again measures that a state might want to take would include criminalizing massive environmental harm. So just a little flag there for the crime of ecocide, which would be supported under as a measure to ensure non-repetition. Okay, so that's basically what the court said in big picture. What happens next? So how can we use this? How can we use this opinion to fight climate change? Well, I've already mentioned that the advisory opinion is not per se binding, but what's very clear is that states are now on notice in really quite some detail of what they need to do to comply with international law. So states are clearly on notice of what they need to do. How can they be held accountable is the next question. Well, let's see. But one obvious avenue is state-to-state actions. So diplomatic claims, of course, but even possibly cases brought to the International Court of Justice, if there's jurisdiction. States could potentially bring cases against other states for failing to prevent significant harm, or there could be claim for reparations and loss and damage, particularly by vulnerable states against the major emitting states, especially the major historical emitting states. Perhaps more likely or easier would be domestic actions by citizens and NGOs, organizations, based on these now clarified legal obligations. So citizens may challenge their government's inadequate climate policies, citing the ICJ opinion, or they may make claims under international human rights law, which has also been clarified as very relevant in the opinion, or there may be corporate accountability cases. So victims and organizations, civil society groups may argue that states must regulate companies more strictly, and they might also use the opinion to frame civil suits against major emitters. And then finally, international and diplomatic follow-up. The Paris Agreement negotiations are going to be really interesting with this advisory opinion. It will be very interesting to see what happens at the upcoming COP and how this opinion is used in negotiations. But essentially, it must be able to be used to demand more ambitious, nationally determined contributions and stricter review. And at the UN General Assembly itself, I understand that work is already underway to translate the opinion into resolutions on finance, adaptation, and accountability. We might also see precautionary moratoria, for example, on deep sea mining, grounded in the duty of prevention and precaution, which was mentioned in the opinion, as well as it being cited, the opinion that is in trade, investment, and certainly human rights fora to defend stricter climate measures. But let's be realistic, law alone is not going to solve this crisis. The ICJ cannot actually save the planet, but its ruling really does provide the legal compass that we need. It clarifies that states have stringent duties, that we have rights, and that the law demands ambition from states, not complacency. And I wanted to close with the closing words of the president of the court himself, because if you haven't heard them, they may not be the words that you would anticipate coming down from the International Court of Justice when considering a legal advisory opinion. So the president said, and I quote, "These advisory opinions are unlike any that have previously come before these advisory proceedings are unlike any that have previously come before the court. They concern an existential problem of planetary proportions that imperils all forms of life and the very health of our planet. International law has an important but ultimately limited role in resolving this problem. A complete solution requires the contribution of all fields of human knowledge. Above all, a lasting and satisfactory solution requires human will and wisdom to change our habits, comforts, and current way of life in order to secure a future for ourselves and those who are yet to come." So through this opinion, I think the court has really done its part. And now I guess it's up to us to decide whether and how we will act. Thank you very much.
Thank you very much, Kate. It's a brilliant and very synthetic and to the point presentation, both of the proceeding, your work of Margareta and you and many others, as you said, some 80 or 100 contributions of legal nature, and for an incredible result. So you presented the UN General Assembly step unanimous adoption of the resolution, which means something. And now this advisory opinion, if not binding, at least which is full of, which has, as I said, the doxa and the advisory opinion of the courts cannot be thrown away. On the contrary, and are guiding states in their actions in a obligatory manner. If it's not binding, it's called obligatory. So you also express some dimension of the consequences and what steps which can be taken now eventually, and the potential it has. So I would start with the first question before leaving the floor to everybody and our president also waiting for asking you some questions. It's as you said, it challenges our way of life, but it challenges the economy of fossil fuel economy, which means most of the production and consumption of today. So it questions, in political terms, the very model on which we are based for the sake of our environment and our life and health. What do you think about that?
I think the opinion is really far-reaching in that regard, actually. As I highlighted, they actually went so far as to set out that the granting of fossil fuel exploration licenses might be an internationally wrongful act. I mean, they actually detailed the fact that engaging, supporting, that giving subsidies for fossil fuel use may itself be an internationally wrongful act. And to reiterate, I didn't mention it in my presentation, but you mentioned in the introduction, this was a unanimous opinion of the court. So 15 international judges agreed to put that in the decision. I mean, it's a very pointed reference. And of course, they had heard extensive arguments from fossil fuels producing states that would have encouraged them to back away from a statement like that. So I think the opinion really provides a lot of support for the transition away from fossil fuels. And of course, as they say themselves, it's not the only solution. I mean, in order to transit away from fossil fuels, we have to have alternatives, right? And we have to change our way of life and our expectations, but we also have to have the scientific developments to enable us to do all the things we want to do in another way. But I think the court really went as far as it could have done in saying international law supports that transition.
Mm-hmm. I see no question on the chat. Bernard, I have plenty of questions, but I don't want to mobilize the attention.
No, I'm sorry because I have a very bad connection and I have not been able to follow integrally your presentation. But maybe I have a question. Maybe you have already answered to this question, but it's more specific to our preoccupation in your association, NGO. I will continue in French because maybe it's complicated to explain. Because dans notre association, nous sommes très préoccupés par le fait que face aux menaces, aux périls globaux qui sont existentiels pour la planète que vous avez évoqués, notamment le climate change, euh, voilà, les solutions qui sont mises en œuvre, en particulier à travers, par exemple, les COP, etc., etc., bon, nécessitent une action collective. Donc, où le droit international et le respect du droit international est fondamental. Or, on voit bien que, à l'heure actuelle, nous sommes dans une dérive complètement opposée où le droit international n'est plus respecté, où les lois, où les jugements, oui, les jugements qui sont rendus ne sont pas respectés non plus, et que donc chacun se réfugie, chaque État, chaque pays se réfugie dans une action personnelle, où chacun joue son propre jeu. Donc, comment faire en sorte dans l'état actuel des choses, bon, je pense que c'est insoluble pour l'instant. Comment peut-on faire pour que ces deux trajectoires, l'une qui est celle de l'avenir, c'est-à-dire celle de l'action collective pour répondre à ces menaces et donc qui nécessite un droit international qui soit respecté et reconnu, alors que le monde d'hier, qui est celui du monde que nous vivons actuellement, est sur une autre trajectoire complètement opposée. Comment peut-on faire pour qu'elles se rejoignent? Voilà, donc excusez-moi, c'est une question bon, qui renvoie quand même au respect du droit international et comment le faire respecter d'une certaine façon.
Thank you very much. So to summarize the question, maybe in English, this may be a very helpful opinion, but international law is kind of going down the toilet. So how do we get, everybody's retreating, the multilateral system is being fragmented. How do we get back on track to collective action, which is what we need to do to solve the crisis? So, I mean, you're absolutely right, of course, to bring that up as a major challenge. I think, however, despite what we see and the flagrant ignoring of international law in these many high-profile situations, what we also see, but maybe is not highlighted quite so much on a daily basis, is litigation within states, for example, or in regional courts, which is going in the right direction and which is building up a body of law and practice. I mean, I think, a case under international human rights law or the European Convention on Human Rights in a country like France, if successful, is going to have an impact on the actions of the French government. I mean, they're not going to ignore it, decisions of their own court, right? And I think that's, of course, true of most countries around the world. And these things are happening. The amount of creative, brilliant litigation already, even before this advisory opinion, was staggering. You know, so many creative activist groups and lawyers thinking about how they can change this trajectory through the courts. And this opinion gives a whole new toolbox for doing that. And these cases, they look at each other. You know, they're transnational. You can cite cases from one Supreme Court in another jurisdiction, especially if they're in similar kinds of regions or similar kind of legal systems. So I think this is going on. And I would say probably to myself more than to anybody else, seeing as I'm an international lawyer and I need some reason to carry on, that these big high-profile failures, which are very worrying and devastating for the people concerned, are not the whole story. And it's still worth carrying on trying to build these edifices, which I think, you know, that is going on in the background.